Yes, Mr. Reedy. I think you may be... I can't hear you. You're muted.
Oh, I'm sorry. Should know by now. Can you hear me now?
Yes, sir.
Great. Well, I can't see Lord Justice Underhill, but maybe he hasn't spoken. So that's why.
No, I'm afraid because my watch was behind everyone else's, but
Apologies.
yeah.
The fact of equalisation, the short submission is that in relation to that, Parliament evidently disagreed with the proposition and disagreed since 1995 that there was a need to maintain direct inequality in the state pension age because women born in the 1950s were at a broader economic disadvantage. Their judgment was that equalisation in the modern world was the appropriate judgment for all of the reasons that I've gone through and don't repeat, including that the disparity in state pension age was fundamentally at odds with modern social values, but also for all of the other reasons I've gone through. It is said, I think, in relation to the fact of equalisation and those economic disadvantages that the government did not recognise that equalising state pension age indirectly discriminated in the way asserted or had those effects. The first point to make in relation to that submission by the appellants is that it isn't the government that we're dealing with here, it is Parliament. And as Lord Hope pointed out in the Wilson and First County Trust case, tab 26 in bundle 2, don't need to turn it up, at 116, as he put it, it is no part of the court's function to determine whether sufficient reasons were given by Parliament for passing an enactment. But the fact of the matter is that whether you're dealing with Parliament or the government, it is entirely evident that that submission is simply wrong on the facts, and that Parliament and the government did recognise historical disadvantages suffered by women, the measures that might not have been taken to address them, and their gradual diminution over time. And if one wanted simply one example of that, and that's perhaps all we need, it's in the 1993 White Paper at tab 5 of the supplemental bundle between 151 and 152. I should say that if the court is interested in that set of issues, we did produce below, although it hasn't made its way into these bundles, a kind of 2 or 3 page note setting out that precise recognition in the pre-legislative materials at each stage of the legislative process and progress. We put that into the court below, collating the references that indicated entirely clearly that at each stage that position of historic economic broader disadvantage was recognised. So we have that if you need it. I suspect you won't, because there's enough probably in just in that short extract from the 1993 White Paper, but if you suddenly think you do want to see that, it was a document submitted below, so it can easily be provided.
Sorry, what were the references in the White Paper? I've written down 151 to 152. Is that paragraph numbers?
I think that's pages in the bundle, I think.
All right.
Let me just double check. Yeah, it's pages in the bundle.
Thank you.
Tab 5. Other than that, all of the factors that I've gone through, all of the features bearing on the approach that the court should probably take, all of that is the same, effectively, as the justification points I made earlier. They transpose directly over, because they go to the basic legislative choices that were being made, and I don't repeat them. I simply note in relation to the sea-door question, that is whether or not sea-door affects justification. There's a controversy that you perhaps don't need to get too sucked into, which is the extent to which international legal materials, it's all of the United Nations Convention on the Rights of the Child in my experience, but the same in relation to the Disabilities Convention, here in relation to CEDAW, there is at least a live question as to whether or not the Strasbourg jurisprudence, which is normally the route in to bring in what would otherwise be an unincorporated treaty so that it becomes relevant to a domestic legal analysis, the route in is normally through the HRA, with the submission being made that Strasbourg, in its judgments under the ECHR, does pay attention to international legal materials. But there is something of a debate in the domestic jurisprudence around whether or not that is restricted to circumstances where you are dealing with the interpretation of convention rights, as opposed to it being a freestanding thing that you can take into account in the context of justification. Again, I suspect that isn't a complication that's going to go anywhere in this case, but if you wanted an analysis of that as an issue, can I refer you to Lord Justice Leggett in the two-child case, which is going to the Supreme Court later in the year, SC, which is in tab 44 of the authorities bundle, number 3, third authorities bundle, tab 44, and the relevant section of the judgment analysing that issue I've just described is 111 to 120. You don't need to get into the analysis, I respectfully submit in this case, and that controversy or potential controversy as to whether or not you can rely upon an international convention to try and support a pure justification argument, or the lack of justification argument. And you don't need to do so because it's evident that the Divisional Court fell into no error in this respect. They noted the submission that was made below in relation to CEDAW at paragraph 67 of the judgment. They evidently considered it but found it to be of no assistance, see paragraph 75 of their judgment. So that's what I wanted to say on justification on indirect sex discrimination. Can I turn to notification?
Yes, thank you.
So far as notification is concerned, a duty is said by my learned friend Mr. Mansfield to lie in public law, presumably on the Secretary of State, to notify the various legislative changes. And we respectfully submit that the Divisional Court was entirely right to reject that set of arguments, essentially for three reasons. The first reason is that there is no duty, and it will be positively contrary to established principle for there to be a duty to notify those potentially affected by primary legislation of the terms or effect of that legislation. The changes here were made in primary legislation. The position in principle, back to the Wilson case, at 192, quoted in the Divisional Court's judgment at 114, there is no expectation that Parliament will not act to change the law. And of course, primary legislation attracts all the public scrutiny associated with its passage through Parliament and its enactment. A fact.
That's a different point, isn't it? That's obviously right, that there's no expectation that there's no legitimate expectation that the Assembly will use that. Parliament will not act to change the law. But that doesn't undermine a proposition, if it's otherwise good, that having changed the law, in certain circumstances, Parliament might be, or not Parliament, the Secretary of State might be under a duty to notify those affected of the effects.
Well, I think my answer to that is that one needs to be a bit careful about treating them as too hermetically sealed as points. Because I do submit that if the position is that there is no duty of any description prior to Parliament changing the law, then one has to posit a situation where the fact of enactment suddenly brings the non-existent and constitutionally unsound into life. And it's difficult, I respectfully submit, to keep the duties, when you're analysing whether they exist at all, as hermetically sealed. So that's one point. But in relation to the position that you put to me, which is what happens once enacted, there are two problems with once enacted, and they're fundamental. The first problem is that Parliament could have said, and did not say, in the legislation that we now assume has been enacted, you have a duty to notify. And when it wants to say that, it's quite capable of doing that. The second problem is...
Can I just ask you, are there any examples where it has so provided?
I don't know whether they would have happened in relation to primary legislation. I think the working assumption is that primary legislation is taken to be understood. And to be
I'm not querying that. It's just that you said Parliament could have provided, so I just wanted to know whether it ever had done.
I'm not aware of any,
No.
but I'm not sure that undermines the could point.
No, not at all.
It's a very odd constitutional thing for it to be doing,
Yes.
particularly given assumptions, for example, that people are assumed to know and understand the criminal law. It's no defence to turn up and say, well, look, I was adversely affected because you changed the law by way of statute in relation to some serious crime. You don't get very far if you turn up in a criminal court and say, with that extremely adverse impact, and say, I'm frightfully sorry, I didn't understand.
That's a different point, because the class of people who might commit a serious criminal offence is not a class that you can readily identify, whereas the class of people affected by this is a class who can be readily identified.
Well, potentially they could be.
I think you're right that ignorance of the law is no excuse, but on a notification point, I'm not sure that that's a strong...
It may not be a complete answer, but it is nevertheless a point, because it rests on the fundamental assumption that people are assumed to understand the laws that affect and apply to them. And if that exists as a general proposition, of course, one can make a case of principle for saying, well, it's a bit narrow if you can identify the class. Then you start drifting into legitimate expectation territory, which I'll come to in a second. But just to finish the second problem, once enacted, the second problem is that the overriding public law principle is that the executive administers and complies with the system in primary legislation as it is from time to time. And so you have to then question how the principle of public law will work. I mean, you'd have to ask, first of all, if it's a principle of public law, who does it apply to? Is it to those directly affected? Is it to those potentially affected? How to determine the group is not, and may well not be, a very easy question in some contexts at least. Does it apply in relation to all legislation, or simply because the legislation affects someone? How is the duty to be complied with before or after the legislation? What level of notification would be sufficient? And perhaps most importantly, what if it isn't complied with? Does that affect the rights and duties imposed by Parliament in the primary legislation? And if so, how? So Parliament could make the change, but if a person is not notified before or after, then the rules don't affect them in some way. Common law or public law doesn't disapply primary legislation. So what? You get a bare declaration with presentation or political effects. The problem with that, of course, is that legitimate expectation operates to render a failure unlawful. So you have to afford procedural or substantive benefit thereafter. That simply doesn't work in relation to primary legislation. So there are a series of principal difficulties, and we respectfully submit fundamental objections with the idea that when Parliament hasn't said notify for, I respectfully submit, understandable and pretty deep-lying constitutional reasons, the common law could suddenly come in and invent one. And that takes me to the second proposition, which refers to the common law. And the common law has developed, in relation at least to executive policy and action, the principles that are legitimate expectation. My learned friend Mr. Mansfield asserted that the case had never been put on the basis of legitimate expectation. My short answer to that is that's a very difficult basis on which to castigate the Divisional Court. Can you take up the core bundle and go to page 118? just with that ringing denial in mind, would you have a look at paragraph 2A of the defective skeleton argument for Divisional Court? Then have a look at paragraph 26 on page 125. Then have a look at paragraph 31 on page 126. But I don't want to rest on a procedural point, although in fairness to the Divisional Court, it's right that you should know that that was the way the case was argued below.
So what was the last reference?
One was paragraph 26. What was the other reference?
Yeah.
I think it was 31, was it? Yeah.
Right.
But my learned friend,
To be fair, you're absolutely right that he does request a legitimate expectation, but he changes, but he says and/or procedural fairness, and by the end of his submission, it seems really clear. I mean, that's really where he started in front of us as well. He saw some of the difficulties with pure legitimate expectation.
well, there's no desire to be particularly fair to my learned friend. Can I
You don't have to be, Sir James, but we do.
Yeah, of course we do, but can I point out that below, the procedural fairness argument was an argument based on Houseman and Fulham and Hazel, and it was based on natural justice cases.
Can I just pause? We've lost visually the Master of the Rolls. Let me check we haven't lost it.
No, I can hear what you're saying, but my picture's frozen. I'll just go out of the video and come in again. There we are.
There we are. I was saying that the procedural fairness argument below, sorry my lady, was
Yes, well, I think also being fair to Mr. Mansfield, I think what he was saying was the case had never been put on the basis of an express representation or undertaking to notify. I don't think he was saying it wasn't legitimate expectation, but the legitimate expectation arose from factors other than the giving of or the making of a representation or the giving of an undertaking. That's how I understood the case to be put.
well, really yes, but it's then put on the basis of legitimate expectation. We know it is possible in extreme and unusual circumstances for broader considerations of that kind possibly to found a legitimate expectation, but they're extraordinarily narrow. And perhaps more significantly, so I don't get sidetracked on this issue about who's being fair to whom, more significantly, before this court, my learned friend positively asserts that he can't make out the ingredients of legitimate expectation of any kind. So he says, and said in submissions to you, it must be a broader duty, and then a duty which draws on, in the way the argument appears to progress, precisely the ingredients that he positively asserts he can't make out. And we submit that that's simply untenable as a species of reasoning. The key flaw, perhaps, is that the common law, the public law, has recognised and shaped a set of principles which do not apply to Parliament, I add, and it's a pretty important fact. We don't claim legitimate expectation against Parliament. Common law has recognised and shaped a set of principles on the basis of which the executive is constrained in that way. So the principles of legitimate expectation have been hammered out across all the cases you're very familiar with. Lord Justice Lloyd Jones in Patel and the GMC, Nielsen and Bat Murphy, all of that. But if you remove those underpinning principles, the force which moved the law into that place disappears. So if you positively assert that I can't make out a case of legitimate expectation, that's because you can't make out the ingredients which the law has judged necessary in order to impose an obligation of this kind even on the executive. And my broader submission is that even if you're approaching it on a broader or legitimate expectation grounds and forgetting the denial of the ability to make good an LE case, a legitimate expectation case, the only expectation I submit is that the government will continue to administer the law and the system from time to time enacted by Parliament. in primary legislation. Wilson again, Lord Roger, quoted in paragraph 46 of our skeleton, no one has a vested right to continuance of the law as it stood in the past. So then my learned friend, if he moves from legitimate expectation, or he moves from his, as it were, a jackdaw attempt to try and pick up the bits that he likes from legitimate expectation whilst denying the ability to meet the principled requirements on which it stands, he then says, well, it's necessary for the common law to move here, I think acknowledging that this is a significant development in the public law, brackets, which it certainly would be. He says you can do that, or the legal impetus for developing the common law in this way is in order to correct error by Parliament. As it's put in the skeleton, the 1995 and 2011 Acts, quote, could and should have contained notification duties. But that is no basis on which the common law should move in the very significant way that he identifies by removing the principled anchor from the doctrine from which he seeks to derive substance, namely legitimate expectation. It would undermine the intention of Parliament, I respectfully submit. They didn't enact any such duty, and you can't add a common law duty on the basis that Parliament should have included not to. You trespass very close onto the rocks of Article 9 of the Bill of Rights in any such argument. But there's no reason in any event to depart from the principal basis that the common law has developed, namely the principles that underpin legitimate expectation. If you can't get within those, you certainly can't say something equivalent applies in relation to Parliament. And in any event, as was pointed out in at least one of the paragraphs, I think it was from Bappio and Lord Justice Sedley, quoted in the Divisional Court's judgment, in extenso, if you're dealing with a change of this kind, the invention of a duty of this kind, and here the hermetic seals break down as well, Lord Justice Sedley was there thinking about a duty of consultation prior to things, but exactly the same principal difficulties arise post and in relation to a duty to notify. If you're going to make a change of that fundamental kind, it should be Parliament that does it, said Lord Justice Sedley, and we respectfully agree. That point must apply here as well. It might also be noted, and it's really only a final NB on the second point, and the final NB is that it's not at all clear that a duty of individual notification would not have been more rather than less onerous than a full-blown consultation. Indeed, it couldn't have been done before 1999 or 2000, because there was no usable national database of name, address and date of birth data available. See the judgment at paragraph, the judgment of the Divisional Court, at paragraph 110. The third point is very, very short. It is that the Divisional Court addressed the extensive evidence on this issue, particularly the evidence set out in Wendell Fox's witness statements, at paragraph 90 to 113, and held that it wasn't able to conclude that the steps in fact taken to inform those affected by the changes in state pension age for women were inadequate or unreasonable. And there is no challenge or suggestion or a basis on which the appellants even suggest that that finding is wrong by reference to the standard in the R case. So it fails on the facts even if otherwise sound, but my core and fundamental objection is that it is deeply unsound in principle. That's what I say about notification.
Yep.
The final topic, and then I'm done, is undue delay. The Court of Appeal has, of course, now established that the date for this sort of challenge to primary legislation would run from the date when the claimant is first affected by the legislation. That's the Badmus case, in particular, paragraph 77 behind tab 61. And as they pointed out in that paragraph, the question when a person is, quote, first affected by legislation depends on all the circumstances. So that's the question to be confronted in our context. And my submission is that the date when the claimants are first affected here is either, one, the date when the Acts came into force so as to change their SPA, and indeed we note that their own case on notification precisely depends on the contention that they were affected at this point, because they needed proper notice so as to plan. Alternatively, the submission is that they were first affected at the very latest at the date on which they were first affected by the legislation equalising the SPA, namely May 2010, when the state pension age began to rise, or began to rise, apologies.
Isn't that second one illogical? If you depart from your principled first point, the only logic behind the second point would be that that's when it actually affects them. But surely, since that was a staggered process, May 2010 wouldn't be justifiable in the case of someone who was only affected at some point in the following years.
Well, I think one can extrapolate that point to include those within the stagger at the dates when they're affected.
Oh, I see, okay.
Do you see what I mean? But the logic is that it's when the legislation, as it were, cuts in relation to them, if you want to take that later point.
Yes, but in that, I see that, but in that case, as we established yesterday, one claim is in time and one isn't. Am I getting that wrong? I think I may have misunderstood your submission.
I think you are wrong in relation to that, but I'll be corrected if I.
Remind me, so I should have all this in my mind. Remind me what the significance of May 2010 is.
I think that was the first date on which the.
Well, that's when the taper begins, isn't it?
Yes.
Yeah. So well, then I may still be wrong, but I hadn't misunderstood. Why should, when the taper begins, once you move from the date of enactment, or rather the date of coming into force, that some other class was hit in 2010?
Well, let's see the force of that. I think it is. I think it has to be that alternative submission. It has to be the date on which that applies to you, as it were.
Yes. So effectively, when you get to 60 in practice.
Okay. Yes. Well, that is the proposition that they're putting forward. But in Badmus, although the test wasn't simply when you have standing, it is quite useful to ask the question, when did the applicants have standing to bring a claim for judicial review?
Yeah.
Because, of course, if they were not affected, they would have had no standing. But if they had standing, it was presumably on the basis that there were people who were affected. So it is quite useful, I think, to ask the question, could they have brought judicial review proceedings at an earlier stage than 60?
Well, yes, and that is, in large part, the principled argument that supports the first alternative. Because the fact of the matter is that there could have been no objection to someone saying, in the 3 months or the year or whatever it may be after the 1995 Act is passed, if they turned up and said, well, I'm challenging this on all the grounds that we now see, you couldn't have escaped on a standing basis if you were the defendant, because they had all the weaponry there. They had all the basis on which to challenge there. They could say, well, there's the legislation. It may not be about to affect me in real money terms for another 15 years, but the fact of the matter is it is going to, and I've got the legislation, I can mount the challenge. They could have challenged the 1995 Act in 1996 or the day after.
Well, I think that seems to me to be the issue.
Yeah.
The issue under the badness test seems to me, but I may be too close to it, but it seems to me to be at what point were they affected so as to have standing to bring judicial review. That seems to me to be the badness test at the moment, but I stand to be corrected, and that will answer this question.
My Lord, I respectfully agree, and my submission is that supports the first alternative, because we could not have said, if they brought the challenge within 3 months of the enactment of the 1995 Act, and for this on the grounds of sex discrimination or age discrimination, because they were an economically disadvantaged group of women, and doing the comparisons and so on, all the weaponry was there. We could not have said we're not affected by this legislation. It had been enacted. It will unwind in accordance with its terms unless and until changed by Parliament. You win the challenge.
Yes, I mean, one has to remember that badness was quite an interesting, had an interesting contrast in this respect, certainly from the present case, because in badness, the claimants, when the legislation came into force, were nowhere near a immigration removal centre. I don't know what they were doing, who knows what they were doing. They may not even have been in the country at that point. And so there was no suggestion that they were either affected by or certainly had any standing at that stage or interest in challenging the legislation when it came into force. So I think that's on the facts, the contrast with the present case.
Yes, well, I respectfully agree. But if the standing test is, as I respectfully agree with you, it is, the moniker, if that's the key, then you have to ask yourself, how would the defendant have fared if, in the face of precisely this challenge, notification and the more fundamental challenges to the legislative regime had been made the day after enactment of the 1995 Act? And no administrative court in the world is going to say at that stage, you can't say, you can't turn up as the defendant and say, well, I'm very sorry, they're not affected yet, they're outstanding.
Now, the curiosity, procedural curiosity here, is that at the oral renewal hearing before Mrs. Justice Lang, of course, the point on delay was taken, but it wasn't, of course, argued in the badness way. It was argued on the basis, as I think was argued here by Mr. Mansfield, of continuing wrongdoing or unlawfulness. Now, one of the courses that might have been, and of course Mrs. Justice Lang decided against the respondent on this issue, but it doesn't look as though anybody asked for a rolled up hearing for that matter, as it were, to be left open. And so in a sense that bolt has been shot. I mean, she gave permission for judicial review.
Well, it hasn't necessarily been shot. And it hasn't necessarily been shot because delay is relevant to two things. As you know, we've got to bring a claim promptly, and that's the permission point. But delay, or if there's been undue delay, is also relevant to the exercise of the court's discretion to grant or not to grant relief.
Yes.
The second thing to bear in mind, even in relation to the first of those, in other words, let's call it permission promptness, is that it remains open in accordance with a case called Litchfield, which we can provide to you if you need it. The relevant paragraph is paragraph 34. But it remains possible for the substantive court, in other words, here the Divisional Court, to revisit that issue anyway, in certain circumstances.
Yes,
Well, I think we need to see that.
Sorry?
I think we need to see that report,
Yes.
because that's quite an important point.
I had in the back of my mind that was the position. I'm afraid I haven't done the research you had already, Mr. James, but that's really that. When was it? Litchfield's an older case. I mean, it's not a very recent case, is it?
I don't think it is a very recent case, but we'll have to
the position for some time. Then there's two bites at the cherry on delay. You don't have to do what my lord suggested. I must say I had in the back of my mind. If you want to keep the time point open,
well, we don't have to do that.
you direct a roll-up hearing.
You can, but you don't have to do that. There are slightly more limited circumstances you'll see from paragraph 34 of Lichfield, but the fact of the matter is that what would have to be said here, well, the fact is that here, the substantive court, the divisional court, did actually consider delay. And no one's saying that it was not open to them to consider delay.
Well, I'm not sure about that. Anyway, I think we need to see Lichfield in order to understand, because this is quite an important point, I think.
Then we will provide it. But you also will need to bear in mind when you're looking at that, that the point of permission, or a point of permission to bear in mind, is that the relief that was being sought at that stage was a fundamentally different form of relief. At that stage, all that was being sought was a declaration, I think, that the respondent should review the legislation. And then as the claim developed, and certainly by the time it got to the Divisional Court it was full-blown, it was a full-blown attack on the EU and ECHR compatibility of the legislation itself.
I mean, if you're right about Lichfield, I find it a little surprising that the first issue dealt with by the Divisional Court was not indeed the question of delay. Because you'd have thought, if you're right, and what you're saying is accords with the view of the Divisional Court that it was far too late, that was a knockout blow.
Well, yes, but I mean, I can't tell you, I can't, I'm afraid, help you with why they structured as they did. They knew how to have a weather eye on the bigger picture.
All right.
Well, out of curiosity, and not, but just so one gets the picture, was it in fact your submission below that you should decide this point first, and we can all go home after an hour?
No, I'll take my full share of the blame. I'm pretty sure I didn't put it that way. I'm pretty sure I went at it very much as you've heard me go at it.
Yes.
With this as a kind of tail-end Charlie point, but it was definitely there and argued about, as you see from the written skeletons below.
Anyway, okay.
Well, what is your answer on the continuing failure point? That was the point that found favour with Mrs. Justice Lang.
Well, I think
She held that they were in time, or only a little out of time, because it was a continuing failure.
well, my short answer to that is that that is not a proper or appropriate basis in the case of legislation like this. It isn't. You can't just say that because the legislation continues to have effect, you don't need to worry about the rules. Continuing Act applies in certain circumstances, but where you are challenging the validity, the compatibility of legislation, you have to do that as soon as the grounds for that challenge have arisen.
Well, I think, if I may say so, perhaps another answer is that is not the correct legal test, which is set down in Badness. Badness has explained what the correct test is.
Which is standing.
Which is, well, it's when you're affected and standing, and those are there's no separate legal test for continuing lawfulness in this area.
If there was, I respectfully agree it would undermine that reasoning.
You do get cases, don't you, just so we can see where the distinctions are, where, well, I'll call it continuing effect, because that really begs the question, where continuing effect is an answer to a time point. But I think the proper analysis of those is that there are a series of unlawful acts occurring. They may have all started with a statute years ago, but you are challenging a particular unlawful act done under a statute. Statute's a bad example, say secondary legislation, which turns out to be ultra vires. You can't be debarred from taking that point years later, but that's because you're challenging a particular unlawful thing done to you. Whereas here, your challenge is to the lawfulness of the statute, that is all.
Exactly.
Is that, yeah,
Well, I think that is. I mean, it's partly my Lord the Master of the Rolls point that Badness has reviewed the territory, so query the space which is left for that doctrine to operate at all. But my Lord, I would respectfully agree with you about the nature of that distinction.
yes, well, it may be, I haven't, I'm afraid, read Badness with this in mind, but I don't know whether that analysis was advanced in Badness or could have been on the facts, probably not, but it might have. Anyway, there we are. Not sure.
But in Badmus, there doesn't seem to have been, that I saw, a discussion about whether the claimants had actually to be working and receiving the small amount of pay, or whether they would had standing as soon as they were detained in the centre, even before they started actually working. I mean, that would have been a nice point, but it doesn't seem to have. And were all the claimants there, it may not be clear, actually complaining that money they had received was too.
Right. You could have two factual situations, couldn't you? You have a situation where someone says, well, I'm not going to work for £1 an hour, so they don't actually suffer an unlawful payment. They just, but they're challenging the scheme. But you could have had it if it had been put in terms of, I received £1 and I should have received £5. But that wouldn't work because, well, we shouldn't re-argue about this. That wouldn't work, I don't think, for other reasons. Anyway,
I mean, I'm not going to.
No, I
don't make detailed submissions on Badness when we have the author before us. So I'm not sure what the answer to that.
And I can tell you that the short answer to Lady Justice Rose's point, I think you'll find, is that they were affected and had standing the moment they arrived in the immigration centre.
Yeah. But not before.
Not before, and they didn't have to actually be in receipt of the money.
Yes, so that is an analogy really with the present situation, potentially, that the women are affected even before the actual financial impact of the change when they arrive at the age of 60 and don't collect their pension. They have standing before that actual financial.
Really, yes, but I don't think you need, if I may respectfully say so, I'm not sure you need that analysis to get you there. Just ask the question, how would the defendant have fared if they turned up the day after the enactment of the 1995 Act and said, I'm frightfully sorry, you can't determine this claim at administrative court because these ladies are not affected, these women are not affected. And the answer to that would have been, yes we are, here's the bit of legislation, you can see how it's going to work. It may only hit us in 15 or 25 years' time, but it's sure as hell going to hit us. And all you have for the tapering, for the equalisation, for the points about there being economically disadvantaged in a broader sense at the point the Act was enacted, all of that is available to them. That's what I meant by they have the weaponry. They don't really have the weaponry. It would have been impossible, I respectfully submit, for a challenging JR of this kind to be resisted on grounds of lack of standing the day after the Act is enacted.
you could have had, you just suppose, to test it this way, they had brought a claim, as it were, in the county court on the first month after their 60th birthday, saying, I'm entitled to a pension now, and I haven't had it. And the government says, no you aren't, because as a result of the 1995 Act, you don't get a pension until you're 65 or 66. She says, yes, but that is unlawful. Well, that would be hopeless, obviously, because it's primary legislation. You might get a declaration of incompatibility, but you could have possibly been in a different territory if we deal with secondary legislation. I don't know.
Yeah,
I think we don't need to go there. It's my fault for pursuing that.
I mean, that may not be a helpful analogy, but the basic point remains. Could they have JR'd on precisely the grounds they JR'd now, the day after the Act was enforced? Answer yes. That's the short point. I mean, in those circumstances, you probably don't need the factual findings at all of the Divisional Court, but just so you have them, can I just give you as a final bit of your note, judgment, paragraphs 78 and 79, in which the Court appeals to note that these particular appellants knew of the nature of the impact that was coming at the latest in Ms. Dell's case by 2010-2011, and in Ms. Glynn's case by 2015. But as I said, I don't think in the way that the case has developed and how badness has, as it were, recast the kaleidoscope, that's a terribly interesting set of facts, but you have them there if you need them. Those were my submissions. If I can assist further.
It looks as though no other questions from the bench. Thank you very much indeed, Sir James.
Great.
Now, who's going to speak in reply? I think what would be helpful for us, because we've still got to determine whether or not to hear further on the issue of indirect discrimination under EU law. I think it would be helpful to hear, if Mr. Mansfield, if this is all right with you, I think we'd quite like to hear your reply on Article 7, because if we can finish that, then the judges can consider over the lunch adjournment whether or not we need to hear further argument on indirect discrimination, sex discrimination under EU law. Is that acceptable to you, Mr. Mansfield?
Can you hear and see?
I can certainly hear you. I can't personally see you at the moment.
I can now see you actually.
Oh, I can see you now. Yes, you're there.
Well, what I was going to ask for is whether we could have just a few minutes to confer. But that we won't have a great deal. It's not going to make any difference to the overall length of proceedings. And certainly, if you wish to hear on that point before lunch, if we can just have 5 minutes and then resume, and then we can address that.
Yes, certainly. Yes, certainly. I think that would be convenient. So we'll give you and we'll give you 5 minutes just to think about. I mean, if that's not convenient, it doesn't matter. We would have the advantage of the short adjournment when the judges could consider whether to go further or not. But if that's not convenient for you, we'll proceed in whatever way you want.
No, I think we can resolve this very quickly.
Very well. Well, then, shall we? We'll give you 5 minutes from now to consider the point. Thank you.
Much obliged. Thank you very much.